So, Excellencies, dear colleagues, as we are now formally launching this event on behalf of the co-organizers, it is my pleasure to warmly welcome you and thank you for having joined us as we kick off the first series of the Geneva Rights and Environment Talks in the margins of the Human Rights Council. And warm thanks especially to the Global Cities Hub for hosting the panel of today's session on their premises here at Villa Rigaud. Camelia Kamileva, co-director of the Global Cities Hub, will have the pleasure to formally welcome you soon. In the face of the three planetary and interrelated environmental crises of climate change, loss of biodiversity, and pollution that we are facing, the recognition of the right to a clean, healthy, and sustainable environment by the Human Rights Council and the United Nations General Assembly is an important milestone that has put environmental issues at the forefront of the human rights agenda. The Special Rapporteur on Human Rights and the Environment reports to the Human Rights Council during its March session on issues related to his mandate. The Geneva Rights and Environment Talks aim to harness the opportunity of this moment of the year to reflect on the challenges posed by the rapid decline of nature and biodiversity and the intertwined human rights implications. The talks are also an opportunity to discuss how International Geneva contributes to bringing together the actors working towards ensuring the right to a clean, healthy, and sustainable environment is upheld for all. And we have here in the room with us some of these key actors that are contributing to this global agenda. So we are launching these talks as the current UN Special Rapporteur on Human Rights and the Environment, Dr. David Boyd, who is with us today, is attending his last session as Special Rapporteur, ending the mandate that led to the adoption of the right to a clean, healthy, and sustainable environment with the large support of many stakeholders. We warmly thank him for his engagement, and we'll be today reflecting on a report that he presented last year to the United Nations General Assembly, entitled Paying Polluters, the Catastrophic Consequences of Investor-State Dispute Settlement for Climate and Environment Action and Human Rights, where he raised awareness on the devastating effects of investor-state dispute settlements on a wide range of human rights, environment, and climate consequences, as we will soon hear. So our talk today will be moderated by Yves Lador, the representative of Earth Justice to the United Nations here in Geneva, with whom we are co-organizing these talks. We are also joined today by experts from the Center for International Environmental Law and the International Institute for Sustainable Development, key institutions here and friends in Geneva, who also largely contribute to these topics. And before I hand over to Mrs. Kamileva, who is hosting us, this is also a question we often receive. I would like to remind everybody that the summary of this talk, as well as the video, will be available on the website of the Geneva Environment Network. And with that, Ms. Kamileva, we are in host. So it's my pleasure to give you now the floor, and also to mention that Yves Lador will take over the moderation of this event after your opening remarks. Thank you.
And thank you very much. Welcome to everyone, ladies and gentlemen, distinguished delegates and friends, Mr. Special Rapporteur and speakers. Welcome to the Global Cities Hub premises. In one sentence, the Global Cities Hub is an initiative organization which is co-founded by the City of Geneva, the Canton of Geneva, and the federal government of Switzerland. So the tripartite, all-level, the whole government as we have. And our aim is to find entry points to include local and regional governments or local and subnational governments into multilateral discussions, processes such as the discussions in the Human Rights Council and others. Why? Because on certain issues, local and regional governments are those who are not only implementing, but sometimes are in the driving seat for many issues, such the issues which we will be discussing today. So welcome in our premises to discuss and address today two critical issues, which are the devastating effects of investor-state dispute settlements on human rights, the environment, and climate action. Very difficult topic you have handled for your last report in this position. Probably we will see you around in other positions as you are very active. But also, this is highlighted in the report of Dr. Boyd, the fundamental role of cities and regions in leading the charge against climate change, biodiversity loss and pollution, as we want to highlight. So we are aware that the report does not go much further on subnational governments, so we wish to recommend in a further iteration to this is to be tackled, but obviously this doesn't diminish the importance of it. So coming back from UNEA 6 in Nairobi, which finished just now, I also realized that this issue is also behind the corner there, as there is also a resolution on environmental justice, which is very modest and tasteless, I must say, the interaction of this resolution in the current UNEA 6. And obviously it doesn't give any link to the OHCHR, not linked to the Council. So I wish also to recommend that in the future mechanism also cooperate in these important issues. It is imperative that states, but also subnational authorities closer to their residents and ground problems, realize the potential of taking specific joint actions to avoid future claims under ISDS. They must use more available ways on effective, inclusive and sustainable multilateral climate justice to use the wording of the UNEA resolution and thus fulfill their human rights obligations to use the wording of your report. Empowering local and regional governments through improved governance structures and financial stability are essential steps towards achieving sustainable urban development. And to learn more, we had at the UNEA Summit of Cities and Regions, which was concentrated on finance and environmental justice. So I wish you a very productive debate, leaving the floor to experts, and again, wishing you a warm welcome in our offices. Thank you very much.
Thank you very much, Camelia. It's really great to be here at the Global Cities Hub and in this framework, because I think it's really one of the good places to show the impacts of the issue we're going to talk about today. Because of course, it does not only have state investor-state dispute settlements don't only have impacts on states' policies, but it has also strong impacts on what can be done on the ground. And it deprives, and it has already unfortunately deprived local authorities of the capacity to act on plans that had been even democratically adopted at their own level. So I think it's a great place to be to talk about such an issue. We're also very happy to talk about this because Professor Boyd, as Special Rapporteur, you presented your reports in New York at the last United Nations General Assembly. And as we all know, there is an ocean between Geneva and New York. And sometimes it's an ocean that seems, perhaps because of climate change, I don't know, but difficult to go through. So we really are very thankful to the Geneva Environmental Network, to Diana and to her team, and to all of the speakers joining us this morning to be able to talk about this report, which is a very important one. It has been also commented by a number of states, and we'll have the opportunity to see how a number of states from the north and from the south are directly affected in their capacity to act under these type of agreements and mechanisms. So without any further ado, Professor Boyd, I'd like to give you the floor so that you can present us your views and the report that you presented to the UNGA.
Great. Thank you very much, Yves. Let me just say, first of all, thank you very much to Diana, Camelia, Yves, and my fellow panelists here. It's really great to have this opportunity to talk about a report that was presented to the General Assembly, because I do often agree with you that those reports don't get traction in Geneva the way that the ones that are directly presented to the Human Rights Council do. So thanks to all of you for your support. Some people may think, my God, investor-state dispute settlement mechanisms, what an obscure topic for the Special Rapporteur who only gets to do 2 reports a year. What an obscure topic to tackle. Well, that was my initial thought, but 2 years ago, I was on a country mission to Slovenia, and I really at the time didn't know very much about investor-state dispute settlement mechanisms. When I was in Slovenia, I learned that the government of Slovenia was being sued for over $500 million simply because they had the temerity to pass a law that restricted the use of hydraulic fracturing or fracking for natural gas. And it struck me as a really problematic issue that a foreign investor could use this kind of secretive, poorly known process to challenge the government. And I thought $500 million sounded like a lot. My God, let me tell you, these cases have gone absolutely crazy over the last few years. And I want to step back. I think I'll give you another example though before I just step back. In Panama, last October, the government passed a law that renewed the contract of a Canadian mining company for a project that has been extremely controversial in Panama for decades because of its huge impacts on biodiversity, water, the environment, and local communities. There were protests on the streets of Panama City every day after that law was passed by the government, and there were court challenges brought seeking to overturn that law. On November the 28th, the Supreme Court of Panama ruled that the law that the government had passed was unconstitutional because it violated the right to a healthy environment, the rights of the child, and the rights of indigenous peoples. And so the court struck down the law, which meant that mining concession was no longer valid. Within 24 hours, First Quantum, the Canadian mining company, had announced that they would be filing an investor-state dispute settlement claim seeking a minimum of $20 billion in compensation from the state of Panama. An extraordinary amount of sum for any country, let alone a country like Panama in the global south. And the other example I'll give is we all remember the Urgenda decision of the Supreme Court of the Netherlands 5 years ago, the really historic decision that found that the Netherlands had violated the human rights of Dutch people by failing to take adequate climate action to reduce emissions. And so the Supreme Court of the Netherlands ordered the government to take more ambitious, accelerated action. And one of the actions the government took was to accelerate the phase out of coal-fired electricity. And as a result, the government of the Netherlands faced investor-state challenges from the companies that were producing coal-fired electricity and is on the hook. Those companies are seeking billions of dollars in compensation. Germany has already paid multiple billions of dollars of compensation to coal companies because of the phase out of coal by the year 2038 in Germany. And these cases are just the tip of the iceberg. Investor-state dispute settlement, the mechanism, was created back in the 1960s at a time when lots of countries in the global south were becoming independent, and there was a concern that those governments would expropriate the assets of corporations from the global north without paying any compensation. And it's really remarkable to learn that it was lawyers from some of the world's largest oil companies that were involved in the drafting of those provisions back in the 1960s. The decades went by and not very much happened. By the year 2000, there had only been 12 cases in total brought challenging environmental actions by government. But lawyers who represent these big foreign investors are very creative and realized that there was some potential here. And so the number of cases, which was 12 in total before the year 2000, jumped to 36 in the following decade and to 127 between 2011 and 2021. So the number of cases is growing exponentially. The amount of compensation being sought by these foreign investors is growing exponentially, and the damages being awarded by arbitrators is growing exponentially. So one of the most recent decisions was a decision where a foreign investor wanted to build a massive open pit mine in Pakistan. Pakistan did an environmental assessment, determined that there would be huge adverse impacts of this mine on the environment and on local communities, and refused to grant a permit to this foreign company. The foreign company brought an investor-state dispute settlement case and was awarded $5.9 billion US in damages, which, just to put that sum of money in context, that's more than the total amount that Pakistan received from the international community to support them after the devastating floods in 2021. So this is a problem that has grown by leaps and bounds. And now when we know that we face this planetary climate and environmental crisis, investor-state dispute settlement cases and the threats of these cases have proven to be one of the biggest obstacles to progress. And they're an obstacle in a couple of different ways. Number one is they're extremely expensive. So these governments that are paying billions of dollars to these foreign investors, that's a very high price to pay when you're taking climate and environmental action. The mere threat of these cases, however, is probably even more important because it's created something that the experts call regulatory chill. So governments, when they're considering climate action or environmental action, are being told by their lawyers that if they do action X, they will be subject to potential investor-state dispute settlement claims by foreign investors. And so we know that, for example, in Denmark, in France, in New Zealand, governments drafted regulations that would have brought about the end of drilling for new oil and gas resources in the offshore regions of those three countries, went through the regulatory process, and right in each country, right near the end, pulled back and changed their minds because they were threatened by foreign corporations with investor-state lawsuits. So that's just the tip of the iceberg of examples of regulatory chill. And you can imagine when a country like, take another example, the Republic of Congo. So it's confusing, the Republic of Congo, not the Democratic Republic of Congo, the other Republic of Congo, rejected 3 applications from Australian companies for mining projects because of environmental and human rights concerns. Those 3 Australian companies are seeking $35 billion in damages from the Republic of Congo. The annual GDP, gross domestic product, of the Republic of Congo is $13 billion. So, I mean, it would just be absolutely catastrophic for this developing country that's trying to fund education, that's trying to fund the healthcare system, that's trying to deal with the consequences of the climate crisis, to have to pay 3 times its GDP to 3 foreign investors simply because it thought that these mining projects were problematic. So the very nature of this investor-state dispute settlement mechanism has really transmogrified from what was originally intended. It was originally intended to address expropriations of assets, where governments took companies' assets and didn't compensate for them. But these crafty lawyers, as I mentioned, have taken phrases like legitimate expectations and indirect expropriation and fair and equitable treatment and have made those concepts much broader than they were ever intended and have used those concepts to be successful in these cases. Now, it's really important to understand how these cases work. These cases do not go through the domestic legal system. They go straight to a panel of 3 arbitrators who are not judges, they're lawyers, and those lawyers are not bound by domestic law. They don't have to consider human rights law. They don't have to consider environmental law. They don't have to consider precedents set by other arbitration panels. They basically have carte blanche to just look at the investment agreement and make their decisions based on the facts and that agreement. And so there are now more than 2,000 international investment agreements that include investor-state dispute settlement mechanisms. And they're highly problematic, as I said, because of the way that the arbitration process is structured. So they don't have to consider human rights law or environmental law. And arbitration panels have been very reluctant to consider arguments based on human rights. They have been very reluctant to allow local communities to participate in the proceedings. The process itself is highly secretive. There are literally hundreds of cases that we have no information about beyond the fact that the case exists. The arbitrators, as I mentioned, are lawyers, and quite often these lawyers work for law firms that also represent foreign investors in these international arbitration proceedings. And even worse, there's a practice called double hatting, where a single lawyer acting as an arbitrator can be in one case acting on behalf of an investor, in another case acting as one of the arbitrators deciding a different case, not the same case, but a different case, but the same issues may arise. And so, of course, the it places these arbitrators in a clear conflict of interest. And another problem, as the Pakistan case that I mentioned illustrates, is that some arbitration panels calculate the damages by looking at what are called the sunk costs. How much did the investor actually invest in a project? And then compensating them if there has been a violation of the investment agreement, then compensating them for those sunk costs. In the Pakistan case, and in a growing number of cases, they're not using sunk costs, they're using estimates of future earnings. So obviously a very, very speculative procedure when you're talking about a mining project or a natural gas project to look 20 or 30 years into the future and to make assumptions about commodity prices, about all of these factors. And that's how they came up with this immense figure of $5.9 billion in the Pakistan case. That's how the mining company in Panama came up with this $20 billion figure. The most outrageous claim to date, which just illustrates the trend where these things are going, is a case brought by a foreign investor against Australia. Australia turned down an application for a massive iron ore mine, and the foreign investor is seeking $200 billion in damages, right? Based on projections of future earnings. I don't have all day, so I'm just going to cut to the chase. There is some good news here. It sounds pretty bleak, the exponential growth in cases and damage awards and the problems with the system. We also know that there have been efforts to reform the system. Those efforts are not working, and I'm sure my colleagues will talk about that. There is some good news here, though. The European Union has gotten rid of investor-state dispute settlement between the 27 European Union members. At least 10 European nations have announced they will withdraw or have already withdrawn from an international agreement called the Energy Charter Treaty, and most recently the UK, but also Germany and others. And all of those countries that have announced their intention to withdraw from the Energy Charter Treaty have said it's directly because these investor-state provisions are blocking climate action. So that's encouraging. Also, the renegotiation of the North American Free Trade Agreement between Canada, the United States, and Mexico resulted in Canada and the United States saying, we don't want any part of this anymore. Canada's Deputy Prime Minister said Canada has already paid hundreds of millions of dollars to American corporations, and it is blocking our ability to protect people's health and the environment in Canada. And some countries in the global south, including South Africa and Indonesia, refuse to sign investment agreements that include investor-state dispute settlement mechanisms. So that's signs of progress. There's ways that countries can get out of the mess that they're in. One is to unilaterally withdraw consent to arbitrate. So by signing and ratifying these international investment agreements, they are consenting to the arbitration process. They can unilaterally withdraw that consent. That's the first and the quickest solution. They can also renegotiate these agreements, and there's a lot of these international trade and investment agreements that are being renegotiated, and renegotiate them, and as Canada and the US have done to get rid of these provisions. And then the other option is to unilaterally terminate these agreements. Or unilaterally withdraw from them. The problem with that is that all of these agreements include something called the sunset clause, which means even once you've withdrawn formally, the agreement continues to apply to you for a period of often 20 to 25 years. So for example, Italy withdrew from the Energy Charter Treaty in 2016, but and then subsequently passed a law that prohibited offshore oil and gas development. Nevertheless, because of the sunset clause, a British company was able to use the investor-state dispute settlement mechanism in the Energy Charter Treaty to file a case against Italy, and was awarded over 200 million euros in damages. So, so the good news is, just to summarize, the good news is that a growing number of states recognize the fundamental problems with this system. A growing number of states are trying to reduce their exposure to these cases, and there are solutions. So I'll stop there.
Thank you very much, David. Thank you very much for this very clear presentation of the challenge. We have with us two panelists who are coming from organizations who have been working on this since quite a long time, and actually who contributed to the whole discussion in the preparation of the report. So I'm happy now to turn to Eleanor De Anzizu, and you're a staff attorney working on international trade and investment law for the International Environmental Law Center, CIEL, very well-known organization. So the floor is yours, and thank you for being with us.
Thank you, Yves. Good afternoon, everyone. First, let me extend my heartfelt gratitude to Earth Justice, the Geneva City Hub, and the Geneva Environmental Network, and especially to Professor David Boyd for orchestrating this illuminating session centered around the impactful report that he provided on investor-state dispute settlement. Professor Boyd, your contribution has been really important in this issue, and we will work hard to carry on the legacy of this report. My name is Eleanor, and I represent the Center for International Environmental Law, as mentioned by Yves. CIEL is a legal center specializing in public international law, particularly on the topics many different topics related to international environmental and human rights law. And over the past 3 decades, CIEL has been entrenched on working on international investment law and ISDS related matters, offering expert insight through amicus curiae submissions, as like supporting sometimes affected communities to address tribunals when they have cases that are impacting those communities, and also as legal experts in international environmental law and human rights law, and also advising states regarding those matters, and also negotiating treaties. So what we have seen is that ISDS system while it has evolved, we have encountered from the beginning a plethora of emerging issues that were previously overlooked, possibly due to the infancy of international environmental law, maybe 30 years ago. However, with the pressing triple planetary crisis, being climate change, biodiversity loss, and pollution, it has become clearer and clearer that ISDS is exacerbating those crises and contributing to those crises, as Professor Boyd mentioned. Historically, ISDS has presented numerous challenges, as for example, we saw 30 years ago in Myers against Canada, where the tribunal's interpretation of the Basel Convention contradicted directly Canada's efforts to enforce it. Furthermore, what we have seen is that what was originally, as Professor Boyd mentioned, a more like diplomatic process has now transformed into a highly profitable business, inundating the system with cases from foreign investors' cases. Additionally, what we have seen is also an increase. I mean, the system has always been quite opaque, but it has become increasingly more opaque, even if there has been some reforms or some initiatives led by some institutions to try to make it a bit less opaque. It is highly opaque and much more than it was before. And also what we have seen is that there's an increase of lack of expertise and direct experience on issues related to public international law largely, but in particular in international environmental law and human rights law by the practitioners that address these issues, being as tribunal members, but also as counsel, because many of the lawyers that are coming to those cases come from private law or private international law and have not been dealing with those topics in their own experiences. And that we can see now after in those cases that those issues are not taken into account as they should, or they are problematic, not to say wrongful applications of public international law, international environmental and human rights law obligations and treaties. Additionally, despite some attempts by some states to address these issues, because there has been reforms, and Professor Boyd mentioned that point too, efforts at plurilateral and multilateral process have fallen short, and this has been, for example, witnessed in the context of the Energy Charter Treaty, which went into a lengthy process to align that treaty with climate obligations. But even if we will have, for example, carve-outs and other mentions like reinforcing the fact that states have a right to regulate, even like that, the analysis done by experts, and we have also institutions that at the domestic level analyze this treaty in a reformed way, demonstrated that it's still incompatible with climate change obligations and targets at the national level. So that's why many states have decided to leave such treaty. Today, as nations grapple with environmental degradation, ISDS not only puts at risk to the implementation of international environmental norms, but also erects legal barriers to their development and enforcement. So this is very, very concerning, as Professor Boyd was elucidating. In this regard, Professor Boyd's reports shed some light on how ISDS has distorted international human rights and environmental norms, including the polluters pay principle, shifting the burden of environmental measures economic losses onto states rather than holding polluters accountable. You have to think that many of the activities that are related to those cases are highly problematic from a pollution perspective, and instead of applying the polluters pay principle that we have fought so much to recognize in the past, we are paying the polluters instead of making them accountable for the damage that they're causing to human health, rights, and the environment. This report, the report of Professor Boyd, will serves as an urgent call to action, prompting delegates to urgently address this issue. There are actions that states can take to eliminate, completely eradicate any risk of ISDS, but also to mitigate, being like there's still a risk, but we make it a bit better, or to respond to the risk once the risk arises. There are tools that exist. At CIAL, we have just published a toolkit with the objective of supporting states officials and UN representatives navigating the different options that exist for them to come back home and really work hard on this, because we need plurilateral action, national action, but also plurilateral action in this regard. And in short, environmental ministries, in our opinion, must take the lead on thinking this is an issue. Let's go back to discussing with trade ministers and work on this issue effectively. And it's very important to really consider what would be effective and what would not be effective, because as I mentioned before, reform has been there. There has been some trials, but it has not worked so far. So we have to now think about what is real effective measures that need to be taken. So I will just stop here. I will thank you again, Professor Boyd, for your report and valuable contribution, and everyone for making this scene here in Geneva and beyond. There are actors and experts, such as colleagues at IISD and also ourselves and others, that are highly contributing to this and trying to make a meaningful change in this regard. So there are tools available. Please come to us if we can be of any help. We'll be happy to help you. Thank you.
Thank you very much, Eleanor. And so let me turn now to Joseph Ostronsky, Euro Policy Advisor at the IISD, the International Institute for Sustainable Development. IISD has been working on these issues and also on the general links between trade and environment since quite a while. So Joseph, thank you for being with us, and the floor is yours.
Thank you, Yves, and thanks to all the organizations that made this event possible. Also, thank you, Professor Boyd, for publishing this report, which highlights some of the main problems we face in the ISDS regime. And as the report shows, and other commentators have mentioned, as you know, the reform is ongoing, but it's been very slow and it's been rather narrow. So what I want to talk about briefly is essentially zoning in a little bit on what this regime was for and how it has transformed, and point to some of the directions of how a future international investment regime can look like. So, as was mentioned, ISD has been working with mostly developing country governments, also on tracking on some of the reform processes and publishing various knowledge production materials related to international investment law. And if we look at the ISDS system, as Professor Boyd mentioned, the regime was originally created to protect investors from the global north during the time of decolonization. And essentially, it was, and it still is, an instrument that insures against political risk. It provides investors with one-directional regulatory stability, and I'll get to this in a bit more detail in a second. We often hear about the question of policy space and the regulatory chill, which Professor Boyd mentioned and illustrated in the report, many instances of this. But the real problem is, and that is why I think that the system, and other people think also that the system is problematic in the 21st century, And it is not only problematic in the context of climate change, but also virtually in all public health or public interest measures. It's not only climate change, it's not only protection of the environment, it's not only energy transition, but virtually any regulatory action from the state. And that gets me to that notion of one-directional regulatory stability. In practice of arbitration tribunals, they often invoke this notion of regulatory taking, that the government has taken a measure which amounted to an indirect expropriation. So it sanctions these kind of measures that essentially limit the possibility of profit-making or capital accumulation for foreign investors. But it is totally indifferent and in fact condones the other part of that regulatory taking, that is regulatory giving. So it essentially protects any kind of measures that are there for investors to make profit. And here I think that while we often talk about fossil fuels, especially in the context of climate action, I think it is important to mention that investors in renewable energy have been using heavily the investor-state dispute settlement to tackle governmental measures that affect their profits. We have many cases against Spain, where Spain also had to pay in damages over €1 billion up to this day, but also cases against Czech Republic, Italy, and more recently Romania and Bulgaria. And most of these cases have to do with feed-in tariffs for photovoltaic energy, for solar power plants, essentially. So in the move towards, in taking a climate action, move away from fossil fuels and to support renewable energy, governments often have to support, through different means, through different tools, the market in renewable energy before it gets consolidated. So they provide various incentives, such as feed-in tariffs, where essentially government is subsidizing, so that the investors come in, and once the market becomes consolidated, then eventually there's no need to provide this governmental support. This is the whole idea of the energy transition, essentially. But the problem is that at some point, the governmental support is not necessary, and the investors are getting a windfall. And this can happen when the energy becomes more efficient, that can happen when the energy becomes more affordable, which is precisely what happened in these European cases brought by photovoltaic investors. But that aspect, with the state bringing money in, that is totally irrelevant, because the important thing is that investor invests when the subsidies are in, and if the state wants to roll back these incentives and this kind of support, then it gets slapped with investor-state arbitration and has to pay damages to foreign investors. And this, of course, seriously impacts policy space, not only in climate change, but in virtually any public health measure. So the regime is supportive of regulatory taking, but it's totally indifferent on regulatory giving, towards regulatory givings. And in the context of climate change, I think this is extremely important, because governments need regulatory flexibility and regulatory experimentation. So the regime as it stands and as it operates currently is essentially socializing all the risks that come with investor activity and privatizing the gains. So this is, I think, why it is very problematic. And it's not only that the damages are extremely exorbitant in some cases, going beyond national health budgets, even the whole GDP, as was mentioned, but it's also the defense of these cases is extremely expensive. And for resource-constrained governments, this can be a real problem, because they have to channel serious resources of time and money to defend these cases, instead of putting this money to improving the national legal frameworks, including national judiciary. And this is somewhat ironic, because this regime, one of the rationales for this regime is that this ISDS system, or investment treaty system, improves domestic good governance. But this is very difficult if the states have to essentially spend more money to create and operate within a parallel system, rather than putting this money to improving that national system. And empirical studies have been overwhelming in showing that the regime doesn't improve domestic governance in any manner, and the way how it is structured and the remedial structure of the system cannot essentially do this. So this would be, I think, about the system as it stands. And the another problem with this, and this is where the report also mentions the problem of transparency and participation. And the report speaks about secretive tribunals narrative. I must say that here I have a little bit of problem with this, not necessarily because the tribunals would be would be open to all participants. So I think that the notion of participation in these proceedings by affected communities, but I think it is a little bit, it's problematic because the transparency level of the regime over the last 10 years has improved dramatically. And the information about the cases is sometimes, and the whole ISDS regime can be sometimes better than in many national judiciaries. So I think that the transparency has improved, but it doesn't mean that it is fine, because we still have many cases which we don't know whether they exist. We don't have access to some of the arbitrations. But I think it does sort of disservice a little bit to the regime, because the experts of the system and the arbitration community can say, but this is not true. It's been open and it's been transparent. It's more transparent than many other judiciaries. Excuse me. So I think that it's not really that much a problem of transparency, but it is a problem of participation and access to the system. And here we get again to the national judiciaries and specifically affected communities by foreign investors. No one else apart from foreign investors had access to the system. It is between investors and home state governments. And we know that avenues for holding foreign investors accountable for impacts of foreign invested projects are very unsatisfactory. And again, this regime just means that states have to put more money into this specific exclusive system than improving the other remedial and accountability mechanisms that could be accessed to all, not only to foreign investors and not only to some foreign investors. So now with this, I would just like to close with what can be done with it. I think that the report is excellent in pointing to the ways how to essentially terminate and exit from the existing regime of ISDS by either withdrawing the consent or terminating the treaties or negotiating the treaties either bilaterally, regionally, or at the multilateral level. But I think that there's one thing which is necessary for all of us or anyone who is involved in the reform of process and governments specifically, is that apart from terminating the regime that doesn't work, is to formulate positive agenda of how international investment regime should look like. Because the problems with this regime currently is trying to resolve are really problems of the 20th century and only of some actors of the 20th century. There's many problems, however, in investment government that needs international action, that need international cooperation, and many of them are collective action problems. So really the multilateral action by many governments is necessary. This could be a question of addressing high cost of capital in developing countries through a multilateral platform, because terminating the treaties as we have them is certainly not anti-investment. Everyone knows that investment is necessary for climate transition. It is certainly not anti-international law. It rather creates room and space for having a positive agenda. So high cost of capital in developing countries, phasing out of fossil fuel investment and ending public support for fossil fuels. That again is a typical collective action problem for which multilateral action is necessary. Addressing obstacles and creating incentives for technology transfer to developing countries and regulatory cooperation and technical assistance and capacity building. But there's also treaties can do more in improving the regulatory frameworks for foreign investment, not just facilitating any kind of investment, but addressing specifically the sustainability element and sustainable investment. This could be done through frameworks for transparency, monitoring, and anti-corruption. Could be governments and treaties could agree to or commit to making government contracts transparent and publicly accessible. Some countries have done it more unilaterally, but it would be only better if this were done multilaterally. There could be transparency of national incentives frameworks, common beneficial ownership registries, due diligence reporting, and there's many other areas where more can be done at the international level. And this is where the direction of the reform of an international investment government should go. I'll stop here. Thank you.
Thank you very much, Joseph. Very, very interesting to also open on the other aspects of how we reform the system and what are the challenges we have. Perhaps one very short first comment is that even in a very well-functioning multilateral system, it still takes time to have an agreement for everybody. And one of the advantages of these very often bilateral agreements is they can go much quicker. And then you have an agreement between the state and the investors, and that's done. So in a way, afterwards, you can turn back to your country and look, we've done it. When you're in the negotiation process, it takes time, and we know how this is it's an issue. So actually, I have a question, and before we have a question and answers, and I'll start with you, Special Rapporteur, is in this reform process, what is the specific value or what is the specific contribution that the human rights system can bring in these discussions? Because as we see, part of that is linked to other forums where we have the international trade negotiations, which unfortunately usually do not take enough of the human rights aspects. We see how basically this regime is a regime of its own, not regarding the others, and in a way making governance not possible very often. How do you see the possibility of the human rights approach to be able to contribute and change the path we are on with these type of investments rules?
Yeah, so I'll be forthright in my response and brief, because I don't think that you can effectively incorporate human rights into the investor-state dispute settlement mechanism. I think this mechanism is irreparably broken. And there have been some reform efforts, for example, putting references to human rights in the preambles of some more recent international investment agreements. The early evidence is that doesn't make a shred of difference in terms of the actual arbitral decisions coming out of those controversies. So I do think that we need human rights to be a fundamental part of international investment agreements going forward. But in terms of investor-state dispute settlement mechanism, I think it's a non-starter.
Any comments from the other panelists?
Yeah, I totally agree that human rights must be a fundamental starting point for any new regime of investment governance. And I also agree that ISDS is not the place where to invest more, how to improving human rights accountability of foreign investment activities, for instance. I think where treaties or investment treaties, if we don't think about them in the way as treaties for protection of investment, can help or improve or contribute to solving the accountability problems by, for instance, obliging states for making their home courts available and not particularly burdensome for civil and tort liability of their investors. That means making essentially the national judiciaries available where investors can be sued. So that, I think, is much better solution than trying to somehow retrofit human rights to the system that is between investors and state. Again, of course, there are investment obligations as one option, but if the government is the only party, I don't think this is sufficient. It needs to be open to everyone. But again, then making an alternative system where we get investors, local communities, governments, why not to improve the existing judiciaries?
I think in part, what it's important to think about is how governments are going to think about what type of investments they're going to accept in their territory. I think it's just that we're going through a phase in which historically there's a lot of change regulatorily speaking from an environmental perspective, because again, the triple planetary crisis. So I think in part one of the answers is going to be also coming from states at the domestic level to reassess their investment approaches, what type of investments they agree to support and which ones they don't. That's on the one side. In terms of ISDS, on the other hand, there has been studies that demonstrate that ISDS itself does not effectively attract or secure foreign investment. So an alternative is needed. I'm not going to suggest what I'm going to say is the alternative, but I think it would be interesting to try to have an analysis, for example, of the WTO system that we know has its own problems, the WTO in general, and we saw last week at MC13 also some issues regarding civil society participation and arbitrary arrest and things like that. So I'm going to park that there for a second, but thinking that besides the fact that right now the dispute settlement system has been blocked for many years, is there something that we can take on board from that experience over the years? Is there any proposal that would work at the international level? I don't have the answer. It's something that I think some countries are thinking about, but definitely one of the ways forward is to think about how do we reinforce domestically the systems that already exist, to give access to remedy and to create something that is coherent. And for that, it needs local action and domestic action, but also to have some form of harmonization at the plurilateral level. So we need to keep having those discussions, at the UN or elsewhere.
Well, thank you. Obviously, I take it from all of your answers that as we see, a lot of this discussion are perhaps not always as developed as they should be at the national level, and that the human rights approach can help the people and the governments to understand better what is at stake and perhaps help them make decisions. I know, Special Rapporteur, that you're going to have to run to a next meeting soon. But still, I think we have a bit of time to take some questions. So I'll turn to the room, and also for those who are looking at the net to see if there are questions that are being raised. And we'll take a series of questions, and so you'll be able to answer, all three of you, to these different elements. Please.
Thank you, Yves. Good afternoon, colleagues. My name is Andrea from the Indonesian Mission in Geneva. First of all, thank you, colleagues, for making this event. It's a very interesting one, and not the topic that we used to have. And I think, a personal thing, this is a very dangerous topic. And I was very surprised that the Special Rapporteur came up with this issue. I mean, we think that you should be protected at all costs of this issue, and we really appreciate this. But to give a little context, Indonesia is one of the countries who have been facing this issue. We did receive many investor ISDS claims. Even from the 90s. The Amco case is one of the famous cases, and maybe the first, one of the first ISDS cases with a big amount of claim. Lately, we've been winning those cases, fortunately. And we are trying to do what you are proposing to do in your paper, withdrawing from all models, VITs, trying to adopt the new ones, and including by putting norms that can protect us better. And we have been trying to do that, and we are also following the discussion in UNCITRAL on ISDS reform, which unfortunately they have not been following lately because in Geneva and not covering Vienna. But we're trying our best to follow this, of course. And within our country, we have to maintain balance between these two issues, between protection and also investor protection. And it's not something that is easy as government. But we are trying our best to do what is best for the environment in particular. Your paper is very interesting, and I think it's important because it provides information to many countries which might not be aware of this big issue. As I mentioned, we are also we did what you have put in your paper. But perhaps I think it's similar with what Yves mentioned. What can we do in a multilateral level? Because what we have been trying to do is bilaterally revising our VITs, FTAs, regionally as well, multilaterally maybe in UNCITRAL, but perhaps there's a way to do it faster and better. Yes. Personally, I was thinking of maybe we should do something about the New York Convention on the recognition of arbitral awards, because I think that's the issue. Because sunset clause is working, is dangerous because we have the New York Convention. Perhaps the human rights people in Geneva and environmental people in Geneva should think of something multilaterally, to address this, because to be honest with you, I think this is a matter of governments versus private, because I think all governments, including from the north, which was mentioned by, I think you said, was the origins of this regime. But now even they are afraid of this. Starting with EU, Canada, and US, as mentioned by the panelists. So it's more something between governments and private. But of course, government must maintain the balance, as I mentioned before. Is there something we can do at the multilateral level, perhaps through the human rights resolutions or UNGA, or maybe do something about the New York Convention on Recognition of Arbitral Award, so we can sort of stop this or make this issue more balanced. So it's not only protecting one side and, as you mentioned, killing the other one, like as you mentioned, it's not polluters who pays, but governments who pays the polluters, which is, I don't think is good for everyone. And perhaps this is my question for the panelists. Thank you.
Yeah.
Great. Thank you.
Thank you very much for this question and from this experience from Indonesia. And let me say also that I know everyone of you mentioned Slovenia. Unfortunately, was unable to join us. They are in consultation. I was with them not a short while ago, and they're unable to come because of different consultation going on with the Human Rights Council. But you know very well how interested they were in your report, and your visit to Slovenia was a starting point precisely of this work. We have also received a question online from Nicola Alarcon. What can local communities do in response to ISDS? Participation in investment arbitration proceeding is almost futile. And basically it's reduced to amicus brief. If ever, that's not a real participation, it's just a contribution. And what are the chances that human rights litigation at the domestic or at another level could help to counter the effect of ISDS? So we have here two very interesting questions, and I'll turn for a final round. I'll start with our panelists, and then you'll have the final word, Mr. Special Rapporteur.
Yeah, thank you, Yves. Yeah, at CIAL, actually, we have worked with affected communities for a long time. In fact, many years ago, it was way easier to be accepted as amicus curiae. Today, it's nearly impossible unless, those communities have also, for example, brought legal claims against the investor or have in a form been related to the actual claim. But besides those very narrow possibilities, it's nearly impossible. But there are other things that they can do. They can campaign at the domestic level for the governments to change their strategies around how they are approaching these investment agreements. They can also bring those voices here at the UN, for example, and to make those cases unacceptable. Not legally, because they are still ongoing, but trying to raise those issues here to have it visible at a multilateral level. Those are some ideas. In our toolkit, also in the last section, we provide some ideas and guidance for affected communities and local communities alike that want to take action. So that's something where we go more in detail if it's useful. Thank you.
Thank you very much. Sure.
Thanks. Yeah, I think I'll take the question from the distinguished delegate from Indonesia. That is about what can be done and regionally and multilaterally. And I think that what was interesting that you framed your intervention as there's this balance between protection and promotion of investment. I think it is totally right that investors want to have some sort of protection. But what Eliana already mentioned, that the empirical evidence showing that investment or international treaty protection with arbitration leads to more investment, leads to development, leads to sustainable development, that is simply not there. I mean, the evidence is overwhelming that these treaties do not help promote investment. But it doesn't mean that the investors are without any protection, and that is simply not the case. They have national legal frameworks, they have political risk insurance that they can pay as opposed to ISDS. So this is something that they bear the risk for their decisions. And their contracts. And with contracts, it's a bit tricky because then you can have arbitration still. And so I think that that notion that if there's no treaty with investment protection, investors are just left there for abuse by governmental sovereign power, I think that that's just nonsense. And empirically, it's been proved that it doesn't work. So I don't think that treaties with investment protection continue to be signed. How to move this forward? I think that the regionalism is probably the good sort of segue from the bilateral negotiations. And I think that the example of the AFCFTA investment protocol, although we still don't know how it's going to be completed exactly, but it is a modern treaty. It is a treaty which has positive elements of investment promotion, investment facilitation, has a lot of sustainability elements and very, very limited protection and no investor-state dispute settlement, at least for the time being. So if one continent can agree on their model, they're in much better position than when they negotiated treaties with big powers where the bargaining power might be unequal. Now, one note on the New York Convention, I'm not sure if this is the best way to tackle it. It sort of tackles the problem of ISDS from the back end. But I think that the problem with New York Convention is that the investor state or the private versus public element for New York Convention is just small, tiny part. The majority of users of investment protection are companies in business to business arbitration. And so the New York Convention is a framework that helps Indonesian investors abroad or Indonesian investors in Indonesia or elsewhere as much as foreign investors in Indonesia. So I think that is sort of shooting oneself in the foot by trying to tackle the New York Convention. If you don't have access or consent to arbitration in your treaties, you already have a control over the contracts where you know that there has been a trade-off for access to arbitration, etc. So I think that the consent is more important than the enforcement and recognition.
Thank you very much. Mr. the Special Rapporteur, the final word.
Yeah, just to say thanks to my fellow panelists for a very thoughtful discussion this afternoon, and thanks for these great questions. In terms of what can be done, I think that one of the really interesting follow-ups is I had a request from the presidency of the G77 after I made my presentation in New York to have a meeting and talk about this. We've since had 2 meetings, and I think that is a forum in which countries in the global south could form a unified position, probably not the whole G77 because it's so diverse, but a group of countries within the G77 that could say, look, we agree with Canada and the United States and European countries that this is a highly problematic system, this investor-state dispute settlement system. Canada right now has said, we don't want to be subject to these cases. That's why they took it out of the successor to the North American Free Trade Agreement. But Canada's in the process of renegotiating bilateral agreements, for example, with Ecuador, and they're insisting that it be in there for Ecuador, which I think is quite a hypocritical position, right? We don't want to be subject to it, but you have to be subject to it. So I think that by getting a group of G77 countries together and saying, look, if it's not good enough for the EU, if it's not good enough for Canada, then it's not good enough for us either. And so those conversations with the G77 are ongoing. I do want to, Josef has mentioned several times contracts, and I think this is something that I didn't address in my report, but I'm concerned increasingly that even if we solve the investor-state dispute settlement problem with these international agreements, the next thing these tricky corporate lawyers will do is go around that, and in negotiating government contracts, so whether that's a mining concession or an oil and gas concession, they'll include investor-state dispute settlement provisions in the contract, in that bilateral contract, which will make things even worse because it'll be less transparent. And I'll give you an example where this is happening right now. 2012, Exxon and Shell are fracking for gas in the Netherlands. They cause earthquakes. People's homes are being damaged and destroyed. So the Netherlands goes, okay, wait a second here, maybe we need to phase this activity out if it's causing earthquakes. Well, Exxon and Shell just sued the government of the Netherlands for phasing out fracking using not an international investment agreement, but a contract that they have with the government of the Netherlands. So that's a danger that we have to keep our eye on. So I do think there's momentum here that's positive in terms of reforming the system. And I think it's incumbent upon all of us to use our efforts to push those reforms. And when I say reform, I don't mean just tinkering with the system. I mean getting rid of investor-state dispute settlement mechanisms because they are so fundamentally flawed. And the last thing I'll say, just in terms of reforms, you know, as a Canadian, there was a free trade agreement between Canada and Colombia, which Canada and Colombia both realized was not sufficient to protect those governments' interests in protecting things like human rights and the environment. So they negotiated a new agreement, which they thought gave each government regulatory space to protect the environment, to protect human rights. Colombia then, after that new agreement was in place, Colombia then turned down a massive open pit gold mine in a rare and endangered ecosystem that provides drinking water to millions of Colombians. And if the Canadian company filed an investor state dispute settlement case against Colombia, it went to arbitration, and Canada actually filed an argument in the case that said, we agree with Colombia that this second generation investment agreement is supposed to give us the space to protect the environment. The arbitration panel said, we don't care what Canada thought or what Colombia thought, we think it doesn't. And so they found in favor of this corporation. I mean, it's completely illustrates how crazy the system is, that a group of 3 lawyers can tell 2 countries that they negotiated a treaty that they don't understand, and that then they can award damages to a foreign investor for having because their rights were violated under that treaty. I mean, that just to me, and that illustrates the problems with trying to reform the system rather than get rid of it.
Thank you.
Thank you very much.
Thank you very much to you.
Having to run.
Thank you very much, David Boyd. I think your example was a good way to show the challenge we have in front of us. Your report has been an important, and we heard that an important element in this discussion. We hope that our small discussion here has also contributed to it. And I'd like to thank again the Geneva Environmental Network and the Global City Hub for hosting us and for helping organizing this event. And I'll give the floor back to Diana for the next events, also on the Geneva Rights and Environment Law.
Yes, colleagues, join the Special Rapporteur and many others at the upcoming events. We have a few talks as part of the series next Monday, but also this afternoon there are a few other events happening at Palais des Nations. We have there's a special event organized by the Special Rapporteur, and there are other stakeholders hosting also some interesting events. So I invite you to visit the page that summarizes the environmental activities ongoing at the Human Rights Council to find out more on what's happening in the coming days. Thank you all.
Thank you. Thank you.